This presentation is all about the cliff edge, offenders who turn 18 during criminal proceedings, but it also extends to those sentenced not long after they turn 18. The phrase cliff edge comes from the Lord Chief Justice's judgment in the Crown versus Clark in 2018, where he said that reaching the age of 18 has many legal consequences, but it doesn't present a cliff edge for the purpose of sentencing. As we go through the transcript, you'll see that the citations for the cases are contained within the script. There are also hyperlinks to other materials there for you. The Court of Appeal has recently reiterated the principle of the cliff edge and the phrase in the case of Cook from 2023. That was an appeal against sentence in a case of non-fatal intentional strangulation, where the appellant was 20. The point about the cliff edge is that an offender, whilst no longer eligible to be sentenced as a youth, shouldn't necessarily be treated as totally adult either. So let's look at the law underpinning sentencing with defendants at the cliff edge. This requires firstly a good look at the purposes of youth and adult sentencing, as elements of both may need to be considered in cliff edge cases. So what we'll do in this webinar is identify the principles underpinning youth sentencing, identify offenders on the cliff edge, look at how the court should modify adult sentencing in cliff edge cases. We'll look at special cases, historic sex offending by young people, and we'll look lastly at listing and good practice with young people at sentence. So let's start with the principles of youth sentencing.